Let's talk about DWIs in New York. What is a DWI and what's the difference between a DUI?
In New York, there's not really a DUI charge, and we hear about this a lot when people call us and want to meet with us. A lot of people describe driving while intoxicated as DUI, which stands for driving under the influence. So DUI is a charge that you see in a lot of other states. I think Florida or Pennsylvania might be a good example. So it's a term that people are familiar with. In New York, there's either driving while intoxicated or there's driving while ability impaired by alcohol. There are some other charges like driving while impaired by drugs, but I guess for the focus of this video, we're gonna focus on driving while intoxicated and impaired by alcohol specifically. I guess you could say that generally speaking, DUI would be an appropriate way of describing driving while intoxicated alcohol, driving while impaired by alcohol, and driving while impaired by drugs as a overarching theme, but it is not a charge that's on the books in New York State.
Okay. So then let's talk about the different levels of DWI. There's DWI or DWAI, DWI, and then aggravated DWI?
Yeah, and that's kind of the order of, I guess, hierarchy or levels. So the lowest level is driving while ability impaired, which would be impaired to any extent. That's considered a violation, non-crime in New York State. What we usually see or what you hear about is driving while intoxicated, which is kind of your standard misdemeanor charge. There's two types of driving while intoxicated. Basically, the police can charge driving while intoxicated on overall circumstances is a fair way of talking about it, or based on blood alcohol content. Blood alcohol content being above 0.08 or higher. And then your highest level DWI is aggravated DWI. That is only chargeable based on an alcohol test, whether it's breath or blood, and that would be 0.18 or higher. So those are really the three levels. I guess to add more levels to it, within driving while intoxicated or aggravated driving while intoxicated, there can also be felony charges. And I think that's something that we're going to get at later. But cases can be charged as felonies if somebody has a prior conviction for driving while intoxicated, or if they're accused of driving while intoxicated and they have a minor in the car with them.
Okay. What about can it become a felony if there's like an accident involved?
It can. It's usually not. If it's just an accident and a regular DWI, it doesn't make it a felony DWI. Where it can be a felony charges like a vehicular manslaughter if somebody dies in the accident, or it can be a vehicular assault if somebody has a serious injury as the result or alleged result of a accident.
My other question on that is, if an individual has prior DWIs, then let's say the third DWI, can that become a felony DWI, or does that not matter?
It doesn't really matter how many total there are for the analysis. It just, you need to have a prior within 10 years.
Okay.
So if there's a prior DWI within 10 years, somebody can be charged with a felony.
Okay. Well, let's talk about BACs. What is it?
It stands for blood alcohol content. There's two ways usually that the police can get to this information. So either the police will ask the suspect if they will take a breath test, and there's a couple different types of breath tests, so I'll go over that quickly. There's one breath test that the police offer people. They call it a PBT, but it's a portable breath test. It's a little device that they can literally grab out of their car, hold it in one hand. They put a straw on the end and say, "Will you take this breath test?" Yeah. So everybody refers to it as a roadside test, or in the business, PBT.
Okay.
That will give an alcohol result. The courts and folks have decided that that is not a reliable test, so it's not admissible in court. So it's basically only used to say whether there was a presence of alcohol or not. We try to see what that number is, because if it's lower than the next test, we want to use that information to our advantage.
Yeah.
But basically, after somebody's arrested for driving while intoxicated, or if the investigation is still ongoing, they'll be asked to go back to the station or the jail where they have a more formal testing equipment. It's usually referred to as a data master, but there's a couple different brands that have this. So the courts have decided that this level of instrument is sufficient to be admissible in court. So they'll bring somebody back to the station or the jail and ask them to do this breath test. The result that comes out of this breath test usually is admissible in court, unless we can make it not admissible.
Yeah.
So it's admissible until it's not.
Well, it's kind of funny. So is there any truth to if you took Listerine right before you did a breath test that it could come back like you had drank alcohol?
Sure. There's, as defense attorneys, we'd be looking for opportunities to challenge the breath result. So I guess there's a number of different ways you can do that. What the police will do if they're trained correctly and are following their procedure is there'll be a 20-minute wait period, they call it. So they will bring an individual to the jail or the barracks, and they'll ask them to basically sit and wait for 20 minutes. They'll observe them, make sure they haven't ate or drank anything, make sure there's nothing in their mouth, and then have them do the test. But I guess to go back to your question, say, for example, our client was in a car accident and the police respond an hour later or 30 minutes later, they've stopped operating the vehicle. That could be an opportunity to consume alcohol after driving,
right,
which would kind of screw up the validity of the test that's about to happen.
Yeah.
So you see this too with people drive home. They make it home. They're in their house, and someone had called 911, or somehow the police end up at their doorstep. And what the police have been trained to do is to say, "Sir, have you had anything to drink since you got home?" Mm-hmm. And they're looking for the person to confirm, "No, I haven't drank since I got home." Sometimes they miss asking that question, and then that gives us an opportunity to say, "Hey, DA, my guy was home for an hour before the police got there. We don't know what happened during that hour." And the police didn't ask the question of, "Have you drank since you got home?" And I guess even if someone says no, I guess we could also argue that some people, in trying to self-preserve themselves, are going to say, "No, I didn't drink," in general, because they're trying to hide whether they drank or not.
Yeah.
So I guess someone could say, "No, I haven't." We would still potentially argue that they might have, or that they did.
So time can affect your BAC levels.
Yeah, so it's something we refer to as either reverse extrapolation or extrapolation. So I guess unpacking that means they are supposed to try to prove what our client's blood alcohol was like, or whether they were intoxicated or not when they were driving, when they were operating the motor vehicle. So to test them 30 minutes or an hour later, is that necessarily the same? And I guess there's two ways of thinking about it, or to simplify it, someone's probably either going up or someone's either probably going down. So an example I guess would give is if someone rips a shot and then goes and jumps in the car, the argument is that shot hasn't hit them until 10, 20 minutes later. If they're picked up right leaving the parking lot,
right,
if 30 minutes later they're tested, their number is going to have that shot in their system, where when they were driving, that shot wouldn't have been. So, but I guess you can have it the other way. Say our client is tested and they are 0.09. They're just barely over. But an hour or two has passed. I could see a DA saying something like, "Jerry, I know you're telling me that your guy was 09, but what was he when he was driving? He had to have been 10 or 11. An hour or two went by. He had come down. He got the benefit of that time, and he's still an 09 or a 10 or whatever the number is." So I guess it can cut both ways. We can try to use that time lapse to help us. We can use it to try to put doubt in the jury's mind, and a DA could try to factor it and say, "I'm not going to give you the offer that you're looking for because I think the guy was higher."
Yeah.
Is it true that you can get charged with a DWI if you're sitting in your car, like just behind the wheel, even if it's off? Or does it have to be the ignition on? Or
Yeah, so operation is a difficult element, I guess, to to always, it's not as straightforward as we'd like it to be. So we've had different cases where folks are sleeping in the car. So the judge in a jury trial reads an instruction to the jury and says, this is what driving or operation is. This is what public highway is. This is what intoxicated is. So there's a legal definition for what operation is. And someone does not have to be actively driving down the road. There can either be information that they were recently driving, either video or testimony, someone's admission that they were just driving, or I guess circumstantial proof that they were driving. But also like these cases where someone's behind the wheel and the car's not moving, the cops will do a couple different things. They're going to put their hand on the hood to see if the hood is warm. They would like to testify that this car must have been recently operating because it's still warm. The keys, they'll say where the keys were. It's better for us if the keys are not in the ignition, but and
nowadays there's no ignition.
Exactly, yeah. So I guess a few people have the old cars still, but yeah, I think just about everybody has moved to push button start. But Toyota Camry was one of the ones that held out for a long time. But they can still prove operation by having keys in the ignition, turned on, seatbelt on. They have to prove that someone recently drove or was about to drive and had the ability to do it.
All right, so here's the question that everyone wants to know all the time, whether, don't drink and drive. The message of this video is obviously don't drink and drive to begin with. But if you do get pulled over for a DWI, the question is, do you take a breathalyzer and a chemical test or not?
And I get that question a lot. I think about it a lot. I guess it's very situational and it's tough to really say for sure. So here's how I usually answer that question. If somebody is not intoxicated, they've had nothing to drink, they should do the test because it's going to come back zeros or very close to that, and you're not going to get charged. If somebody is borderline, that is where it gets kind of tricky to decide. Because it's hard to predict. But if somebody takes the breath test and they are very close to that 0.08, say they're 0.09, a lot of times having that test close to the limit gives us a piece of information that really helps us in our negotiation. We can go in and say, our client's 25, no history, it's a 0.09, it's barely over the threshold. Will you reduce this charge to driving while impaired? The answer there should be yes. It depends on the county and it depends on other circumstances, but that is a piece of information or evidence that would help us.
Okay.
Where it backfires, and there's no way of really knowing after the fact, but let's just say we would know. If somebody was 0.09 but chose to refuse, there's a chance that DA's office is going to have a policy like many do. If you refuse our test, we will not give you a reduction.
Okay.
So you've blown your chances at getting that reduction, and now your case is either going to be a plea to the driving while intoxicated offer, or we have to fight your case. But let's flip this a little bit. Not doing the tests, although it can hurt you in negotiations, and leads to a separate DMV process. It's called the refusal process, but basically if someone refuses to give a breath test, the DMV will schedule a hearing. And if the person is basically proven to have received warnings about taking the breath test, saying if you don't take the breath test, then your license is going to be suspended, and they say, no, I won't take it. If a DMV judge believes that, their license will be revoked for a year. So that is another complication. But where I was going, and I guess let me circle back, is not taking the breath test sometimes leads to a lack of evidence for the DA's office. So these tend to be a lot of the cases that we do take to trial is when someone refuses, because instead of the trial being about the breath test, the trial is about all the other circumstances. How they were driving, their interaction with the police officer, field sobriety tests, admissions or not. So it can be very helpful to me, and I just did a trial on some of these issues. Without the breath test, the DA's hands are tied a little bit. They have less evidence to work with. So one thing I was thinking about, because I just did this trial, is most commonly what we see, though, is someone refuses to do the breath test, but they do choose to do the field sobriety tests.
Okay.
And I think if somebody knew ahead of time that they were not going to do the breath test, it may be a good idea to not do the field sobriety tests.
I didn't realize you have the option to decline
Sure.
the field test,
Absolutely.
but then you're probably getting arrested, right? At like you're probably gonna end up in the back of the car.
Yeah, so I guess
But maybe you will regardless. So,
what police are gonna do and maybe what police should do don't always line up. Sometimes it does and sometimes it doesn't. But basically, if you're not going to participate in the breath test and you're trying to limit evidence that they have or limit things that are going to be used against you, I think most people probably have a bit of confidence that they're going to do well on the field sobriety tests, and then it just turns out that they don't because
Right.
I mean, if you're not in the field, I guess you don't know what they're looking for. I have tons of people that say I did really well on the field sobriety tests.
right, and then you watch the body worn camera, and it's a whole different
Right.
story. Yeah.
So I guess if people knew ahead of time, I'm not doing the breath test, like I'm absolutely not going to do it. I don't know why more people don't ask themselves the question or figure out I'm also not going to do the field sobriety test. So that was the trial that I had a week or two ago. And basically my client did not do the field sobriety tests. He did not do the breath test. So they had to try to prove that he was intoxicated based on their conversation with him, based on him getting in and out of the cop car, and based on his movements at the station. That's pretty limited information. So we did have to do a refusal hearing, and we lost the refusal hearing. So his license was revoked for a year. But at trial, they didn't have the field sobriety tests. They didn't have a breath test. He was found not guilty of all his charges. So in many ways, it worked out for us that he didn't do those.
Right.
But I guess
It's a tough situation. It depends on what's going on.
And I guess if he did the field sobriety test, I don't necessarily know how he would have done. Maybe he would have aced those tests and it would have been to his benefit. So I guess there's a lot of hypotheticals, and that's why it's such a hard question to answer, do the breath test or not. But the question I've really never thought of till recently is, why do the field sobriety tests?